As described earlier in this reality check video series, Plainsight filed suit against 6 federal United States government agencies under the Freedom of Information Act, or FOIA. In all, there were 12 FOIA requests at issue in the lawsuit about 3 individuals: Bola Tinubu, who became president of Nigeria after we started filing the FOIA requests; Moise Adegboyega Akande; and Akande's supposed nephew, Abiodun Agbele. FOIA is really slow. First, you have to convince the agencies that you are serious by filing an appeal within each agency or its parent agency in some cases when they deny your request. And then, when your appeal is inevitably denied, you have to show them that you're serious a second time by taking them to court. Once you're in court, sometimes the agency's attitudes will change and your requests will get what is probably fair to call priority treatment. Having a judge looking over the government's shoulder isn't a guarantee that things will work the way that they're supposed to, but the most egregious abuses of the system tend to get cleaned up as soon as that happens. In the Tinubu lawsuit, the agencies that could find records agreed to produce them every month by CD-ROM or email. Since the Internal Revenue Service and Executive Office for United States Attorneys claimed that they couldn't find any records, or that they'd been destroyed in accordance with record retention policies since they were from so long ago, which was believable, that meant that the Federal Bureau of Investigation, the Drug Enforcement Administration, the State Department, and the Central Intelligence Agency were left. The CIA, for its part, didn't produce anything. Judges like to see disputes narrow over time whenever possible, so for the sake of efficiency, over the summer of 2024, we decided to voluntarily dismiss the FOIA claims against the IRS, the EOUSA, and the State Department, which had only been very slowly producing limited documents about Tinubu's election. But even with 3 defendants down, there were still 3 left, and they were the 3 that mattered the most. The FBI, DEA, and State Department sent over documents by CD-ROM and email for 7 months. Given that the FBI had originally claimed that it wouldn't be producing anything until 2026, that was major progress. But the big problem was that every time the government found Bola Tinubu's name in the documents, they redacted it. For months, we asked the Assistant United States Attorney on the case to explain why the government thought it was necessary to protect Tinubu's name in the documents. The official answer, that the agencies could neither confirm nor deny that Tinubu had any involvement with the files being provided, didn't make any sense. It was already crystal clear from the government's own filings in 1993 that Tinubu was a key figure in laundering money for the narco-trafficking ring headed by Akande. Time and again, I was told that the full explanation could only be provided on summary judgment. To debate the issues any earlier would amount to what the courts referred to as piecemeal litigation. I disagreed with this view because narrowing the issues ahead of time would make document production and the redaction process much more efficient in the long run, but the government wouldn't budge. So, when it didn't seem like many more files that would shed a light on the issues would be forthcoming in July, we told the government to stop processing documents. Finally, we were able to agree on a schedule for summary judgment briefing. Summary judgment is a more efficient alternative to trial, where a judge just makes a decision after the parties are able to agree on basic facts. We were pushing for it to happen faster, and the government was insisting that it needed to be a slow process. We had some success pushing up the dates that the Department of Justice wanted. Then, that schedule had to be submitted to Judge Howell, who fortunately approved. In September, we filed our motion for summary judgment, which explained to the court that the issue is really pretty simple. The government had already admitted that Tinubu was involved. The specifics of exactly how that happened are important. As shown in this series, an IRS special agent named Kevin Moss wrote an affidavit which was attached to a civil forfeiture complaint, basically a lawsuit, filed by an assistant United States attorney with the United States Department of Justice in 1993. But the Moss affidavit wasn't just attached to the lawsuit, it was incorporated by reference. This means that the Department of Justice told the court that it should treat everything Kevin Moss said in that affidavit as though it had been stated by the Department of Justice itself in that complaint. And believe it or not, this entire case hinges now on those 3 words, incorporated by reference. That's because the position of the United States government, as revealed by their motion for summary judgment filings, is that the agencies being sued had never admitted to Tinubu's involvement, allowing them to issue a GLOMAR response where they would neither confirm nor deny that Tinubu had anything to do with these documents. The problem with the government's position is that both the Federal Bureau of Investigation and the Drug Enforcement Administration are component agencies of the United States Department of Justice. So, as the parent agency, if the DOJ already stated that Tinubu was involved because the DOJ incorporated the IRS affidavit into its complaint by reference, then the FBI and DEA would be bound by the DOJ's admission in 1993. To get around this, the United States government was now arguing that the Moss affidavit was merely attached to the 1993 lawsuit. Its lawyers refused to acknowledge that the words incorporated by reference were even at play. The government's summary judgment motion is mostly just a retelling of the procedural history of the case, and then there's a bit of argument about which agency said which thing back in 1993 and whether or not that should now count as official acknowledgement of Tinubu's involvement. It's a bit maddening because this is all legalistic nonsense. Any average person can see what the US government admitted, and it hasn't been a secret for over 30 years. As is typical in FOIA cases, the motion also comes with declarations from representatives of each government defendant agency. In Nigeria, there's been a lot of talk about the CIA representative's declaration, and some Nigerian media outlets have run headlines claiming that the CIA has admitted that Bola Tinubu is a CIA asset. This is false. No CIA lawyer is ever going to admit that any person is or is not a CIA asset, and they certainly didn't do that here. So you shouldn't believe anyone who says that this lawsuit has proven anything about Tinubu's CIA ties one way or the other. However, even though the CIA hasn't admitted anything, it would make a lot of sense for the CIA to be in touch with foreign leaders and to persuade them to support US policy. That's their job. There is some circumstantial evidence of the United States' ties to Bola Tinubu's administration, which is that over the summer, the director of the FBI, not the CIA, visited Tinubu in Nigeria. This kind of thing has never happened before. FBI directors are not usually seen visiting African nations, and it doesn't seem like any prior FBI director has ever visited Nigeria on official business. This, of course, happened while this FOIA lawsuit was pending, in which the FBI is a defendant. So that is certainly interesting. But no one can really say that it proves anything, and it certainly would not prove anything about the CIA just because the FBI director did something. The agencies are fiercely independent. On page 18 of the Memorandum in Support of the Government's Motion, document number 42-1, the government argues that, quote, an alleged public interest in shining light on government wrongdoing cannot rest on a bare suspicion in order to obtain disclosure. Rather, the requester must produce evidence that would warrant a belief by a reasonable person that the alleged government impropriety might have occurred. We actually included that evidence in our motion, pointing out, quote, according to the Washington Post, former FBI special agents Karen and Robert Pertuso were involved in a scandal later in their careers at the FBI pertaining to their joint and simultaneous involvement in FBI investigations despite being a married couple. Even though the government is responding to our motion here, they decided not to address that point. But even beyond the issue of a married couple working for the FBI on the same case time and again, there is obviously public interest in knowing why the US government let Bola Tinubu off the hook in the early 1990s. As for the argument that there are hundreds of millions of Nigerians who care about the issues of their president's background and allegiance, as well as hundreds of thousands of Nigerian Americans who care about the political situation in their ancestral homeland, the US government's position is that the law says that the purpose of FOIA is to shed light on federal government conduct in the United States, and that nothing else matters, not even world leaders who may have interacted with the United States government in the past. The next step in the lawsuit is to file a reply to the government's opposition to the motion for summary judgment. Since it's a two-way symmetric process, that reply will also serve as an opposition to the government's motion for summary judgment at the same time. The government's deadline to respond with its final reply is in January 2025. After that, Judge Howell could take several months to issue a ruling, which means that it's unlikely anything will be decided until the summer or fall of 2025. Generally, the FBI's and DEA's arguments here are weak, which is why the government has avoided addressing the incorporation by reference issue entirely. But nothing is ever certain in court. Anything could happen. Just know that if Bola Tinubu has long-standing connections to the CIA or the FBI or the DEA, and that's entirely possible and maybe even likely, it hasn't been proven yet. But here at Plain Sight, we're doing what we can to get the truth out there.